Hello, everyone. Thank you for joining us for Session 3 of the Introductory Tribal Juvenile Policy and Code Development course. My name is Anna Rangel Clough, and you are joining us at the OJJDP Tribal Youth Training and Technical Assistance Center. And I'm happy again to introduce our guest presenter, Pat Sika-Kwaptiwa. She will be guiding us through Session 3, Integrity of Tribal Juvenile Court Processes as Foundation and Rights and Evidence. And so I know that many of you on here probably joined us for Sessions 1 and 2, but if you missed those, you can email me, and my email address will be available at the end of the presentation, and we can get you links so that you can watch the first 2 sessions. And so with that, we're going to get started. We're glad that you're all here today, and we're looking forward to a good discussion. Again, we'll take a couple minutes just in case we have individuals still joining us. But if you're here today and you've been able to join us from the first 2 sessions, if you want to just share something that you learned in Sessions 1 and 2, I know we've had some really good sessions so far. Share what you're hoping to learn as part of this 5-part series. And again, if you are new, this is a 5-part series. This is Session 3, so we're about halfway through. If you've been able to join Sessions 1 and 2, feel free to share something that you've taken away so far or something that you're still looking forward to learning. And you can enter that in the chat box. Also, feel free to use the chat box to share your name, where you're joining from, what your role is within the court system if you are working in a court system or serving tribal youth. Or if you're an OJJDP grantee and you want to share your program or your project that you're working on, we'd like to definitely know who's joining us today. And I do see several names of individuals who've been a part and joining in Session 1 and 2, so welcome back. And I know Pat's been doing such a good job, and these sessions, you know, they are full of detail, and so we'll share again on our tech overview, but the presentation materials will be available for download. If there's anything from Session 1 or Session 2 that you have questions about, Pat is available for follow-up, and we'll share her contact information. It's also included on the bio sheet that's in the presentation for download pod. Hi, Chris. Guys, for sharing. So really, this is just a welcome. We've, I know, welcomed you all each time, and we appreciate you all sharing your time with us, and we'll go ahead and get started. We have a lot of things to cover today, and so we want to make sure and have plenty of time for the actual content, but we always like to give a little bit of time for others to join, and then also just to share with each other. So I'm glad you're here today. Thank you for joining. If there's any issues whatsoever, or if you have questions about Session 1 or Session 2, feel free to let us know. We can get in touch with you via email for any follow-up about any prior session or this session or any of the future sessions as well. I know we've had a few of you reach out and have been able to give you some information in response. And so thank you all for sharing where you're from, and I look forward to today's presentation. Thank you, Nick. So I already gave an outline of what we're going to do today, but this is just a quick overview, an introduction from our center, and Pat's going to share some learning objectives here shortly. But quickly, you are joining us, OJJDP Tribal Youth Training and Technical Assistance Center. We are charged with the responsibility of being a TNTA provider to CTAS Purpose Area 8 and 9 tribal grantees, and we are very proud to do that and so happy that we're here to serve you. We're housed out of the University of Oklahoma Health Science Center here in Oklahoma City. Our phone number, email, and website are all available there on the slide and in the presentation for download. If you have any questions or needs, feel free to reach out to us at any time. And you can visit our website to learn more about resources and information available to you into any federally recognized tribe. So we're going to do a few poll questions just to get us started today. And so Nick, I'll have you bring those over. And Pat, I'll let you join in as we're reading through a few of these polls. This is just to get a sense of, what's going on in your community and within your tribal juvenile code. And so Pat wanted to think through a few questions just to help with conversation and understanding of the group that's with us today. And so there are a few polls here. The first is, who investigates and questions youth and their families in your tribal justice system? Feel free to share that. Do you have a court coordinator? Is there a prosecutor, tribal police? Who works with the youth to identify issues and investigate within the tribal youth programs? How is the information from investigations or questioning used in your tribal court hearings? And then, can your tribe afford to provide and pay for a licensed attorney to represent youth in tribal court? And this is a yes or no answer. You can also fill that in with more information about your specific community if you'd like to do that. And Pat, I'll let you, as people start to answer, we can work through those quickly.
Okay. So the first question was, who investigates and questions youth? And this is really targeted at, first of all, understanding whether your community has law enforcement. Up here in Alaska, a lot of tribal governments do not have their own law enforcement, and they have to rely on the state officers. They might not have funding to set up their own law enforcement, in which case that activity might go to another court official, anyone from a social services provider to a juvenile probation officer. So it's helpful to think about what role is serving that function that law enforcement would usually serve. The second question is, how does the information gathered from the investigation get used in an actual tribal court hearing? And here we're just prodding to see whether it's law enforcement that's coming in and testifying, or are affidavits on paper collected from witnesses, or are the witnesses actually showing up? Or do we have no idea what's going on in our tribal court process, and we, now we'll have to go and look a little harder and see what's going on? And then the third question is, can your tribe afford to provide and pay for a licensed attorney? I'm seeing two no's there, so that's a real issue. As we'll see from our PowerPoint set today, a lot of the process that the model code of 2016 requires a licensed attorney that's paid for by the tribe. So that's a significant consideration in terms of whether or not you can afford that.
Right, and I was going to say on that first question about investigating and questioning youth, we have a range of answers from state officials, law enforcement, tribal law enforcement, probation, social services, domestic violence advocates. So we know that a number of people within the tribal community may serve a role in working with the youth to identify what issues are present, and then that information that comes into the court system. And so, I think we kind of anticipated that kind of wide range of response, and that is due to the complexities of the tribal juvenile justice system and then the surrounding jurisdictional relationships. So thank you all for sharing. We'll save these responses, and Pat may want to address some of them again later. On our second question, how is information from investigation used? Also a range of answers. So knowing that it's used for either prosecution, behavioral health purposes. Some people aren't quite sure. Some people are new to the court system, and so they don't actually have any familiarity yet. But as you get involved, obviously you'll learn more as you become further involved in the court system. So thank you all for your willingness to share. I appreciate these responses, Nick, you can go ahead and close those for now. Move on to... Okay, so Pat, I'll let you go over the learning objectives for today.
Okay, so the learning objectives for our session number 3 are to really understand the juvenile justice process and particularly court process. We're going to look a little bit at what happens to cases at the level of investigation, but then we're going to look at how that information gets actually used in court hearings. We're going to learn the lessons of a famous U.S. Supreme Court case called In Re Galt that was handed down in the 1960s and what its implications might be for what kinds of court process we need to be having in tribal court. And then we're also going to talk about how in the Indian Civil Rights Act and other rights are implicated in tribal court proceedings. And Anna, do you want me to just keep on going here?
Yep, you have the floor. Thank you.
Okay, thank you. All right, so this is session 3, and I titled it Integrity of Tribal Juvenile Court Process as a Foundation. And we're looking particularly at rights and evidence. I'm going to warn you that this material is very legal. There's going to be a lot of legalese in this section. What I'll try to do is stop and ask questions as we go if I think it's getting a little too dense. Also, feel free to type questions into the Q&A box. And Anna will, if you'll just sort of ping me if you see questions that pop up that need to be answered, please feel free to just jump right in.
Okay.
All right, so I'm going to start us back on that famous case in 1967 that came out of the U.S. Supreme Court called In Re Galt. And I wanted to tell you some of the backstory about it. I know we mentioned it in the last session, but I want to actually give you some more detail. So this is a case that took place in Arizona, and the facts begin on June 8th in 1964 when an Arizona sheriff took a 15-year-old boy into custody. His name was Gerald Galt. And the reason he took Gerald into custody is because a woman, a next-door neighbor of Gerald's, complained that Gerald and another boy were making or made an indecent phone call to her. And after the sheriff took Gerald into custody, he didn't leave any notice for Gerald's parents, and they had to figure out what the heck happened to Gerald. They eventually figured out that he was taken to the police station, and the mom talked to the deputy and found out that there was going to be a hearing the very next day. So the police ended up keeping Gerald in custody overnight, and at the hearing the next day, which we'll call hearing number 1, it ended up being a hearing where nobody wrote anything down. No one in court wrote anything down. It wasn't recorded. No witnesses showed up or were sworn in. The woman who complained about Gerald never showed up. The judge in that hearing said he would think about what he would do in Gerald's case, and then they kept Gerald in custody for another 2 or 3 days. Gerald's mom got a note that there would be a second hearing, which we'll call hearing number 2. Again, at the second hearing, nobody made any record of what happened. The woman who was complaining about Gerald didn't show up. At both hearings, Gerald testified about what happened. And at the second hearing, the judge found Gerald to be a delinquent and ordered him to a juvenile detention facility until he turned 21. So he ended up getting sent to the state industrial school, and he was ordered to be there for 6 years. So just ponder that for a minute, that you have a teenager allegedly making an obscene phone call, and he goes through the juvenile justice process, and ends up getting 6 years in a state industrial school. So in August of 1964, Gerald's lawyer files what is called a petition for a writ of habeas corpus with the Arizona trial court. And the court wasn't interested in hearing that petition, so they denied it and dismissed it. And just so you know, a writ of habeas corpus is a court order where the court orders the agency that's holding someone in custody. Here it would be the state industrial school. It orders them to deliver that individual, who would be Gerald, to the court, and then the state prosecutor or presenting officer has to show a valid reason for why that person is detained. So Gerald's lawyer was hopeful that this would get a review and get him out of the state industrial school. And they refused to hear the petition. So Gerald's lawyer refiles this case with the Arizona Supreme Court, and they also affirmed the lower court's dismissal, and they dismissed the petition for the writ. So this case makes its way up about a year and a half later to the United States Supreme Court. It gets argued before the court in December of 1966, and then in May of 1967, the U.S. Supreme Court decides the case. So let's go to our next slide here. So I wanted to look in a little more detail at those two hearings, because what happens in those hearings is useful for us in thinking about tribal court hearings. So the first hearing that happened on June 9th, if we were in modern times, we would expect that to be something called a preliminary hearing. And what would typically happen at a juvenile preliminary hearing is that the youth would be advised of their rights. They'd be notified of what they were charged with. There might be the taking of pleas, do you plead guilty or not guilty, or NOLO, which is the no contest plea. There might be an appointing of counsel at this point. But that's not what happened in Jerry Galt's case. In Jerry Galt's case, it looks like the judge was actually taking evidence at this stage. So who was present in poor Gerald Galt's case? In hearing number 1, the probation officer was there, and he's the one who filed a petition alleging that Gerald was a minor in need of protection and that Gerald was a delinquent minor, where we find out in the second hearing the official charge would be making a lewd phone call. In hearing 1, his mom was present. Notice that Mrs. Cook, the neighbor, is not present in the first hearing. There's no recording during this hearing. There's no memorandum of record. So we find out much later, from later testimony in later court proceedings, what happened in this first hearing. So at this first hearing, the judge questioned Gerald, and the mother said that Gerald only dialed the number and handed the phone to his friend. And the probation officer said that Gerald admitted making lewd remarks, and the judge said that Gerald admitted making one lewd remark. And at the end of hearing 1, the judge says, "I'll think about it," and Gerald was taken back to the detention home. So then we come a few days later to the second hearing, and by now it looks like the probation officer has filed a report with the court with the official charge of lewd phone calls. So this is the first time that Gerald actually knows what he's charged with, is at hearing number 2. His mother and father are present. The probation officer is present. Again, Mrs. Cook, the complainant, is not present. Gerald testifies at this hearing, but there's a lot of disagreement in later court hearings about what was said by Gerald. So his parents say that Gerald said that he only dialed the number and the other kid made the remarks. The probation officer says that Gerald also only dialed the number and the other kid made the remarks. And the judge said that Gerald admitted making some lewd statements. At the end of hearing number 2, remember, the judge commits Gerald as a juvenile delinquent to the state industrial school until he's 21. And then this is interesting. Under Arizona law, there was no appeal permitted in juvenile cases. So if you were in juvenile court in Arizona in the 60s, which could have happened to me because I was a kid in Arizona in the 60s, you're really screwed because you can't appeal those cases under Arizona law. All right, so let me tell you a little bit about what happens to this case when it goes to the U.S. Supreme Court. So Gerald's lawyer argues in the U.S. Supreme Court that the 14th Amendment of the U.S. Constitution applies to Gerald's case. And the 14th Amendment states that no state can deprive a person of life, liberty, or property without due process of law. And due process refers to the procedures that are followed when someone is convicted of a crime. So Gerald's lawyers were arguing that the state of Arizona had deprived him of his liberty without due process of law, meaning without following procedures that are fair. They argued that the United States Constitution guarantees due process to both juveniles and adults, or maybe I should say adults and juveniles. And it turns out that the U.S. Supreme Court agreed with Gerald's lawyers. And so the U.S. Supreme Court ultimately said that Arizona had to give juveniles as well as adults the following rights. The first is that Gerald was entitled to a right to notice of the charges against him. Both Gerald and his parents should have received a written notice of the charges against him, and that notice should have been delivered far enough in advance to allow them time to prepare a defense. So by the time they find out at hearing number 2, way too late. You know, how could you already have a lawyer ready to go at hearing number 2 if you didn't know in advance? Another right that Gerald had, the U.S. Supreme Court said, is the right to counsel. Gerald and his parents should have been told that they had a right to a lawyer and that one would be appointed for them if they could not afford one. So here we're seeing this idea that the government has to pay for a lawyer for a juvenile who's in that government's court system if they can't afford it. The third right is the right to remain silent. So the Supreme Court said that Gerald did not have to testify against himself, and he did that in both hearing 1 and hearing 2 according to the judge in that case. So according to the U.S. Supreme Court, he didn't have to do that, and so his confession, if he did make it, could not be used against him because it wasn't properly obtained. Now, if it was properly obtained, it could be used, but in this scenario, they weren't seeing it. And then the last right they talk about is the right to confrontation. So if the court didn't have a valid confession from Gerald, what evidence did they have that he made a lewd phone call? Well, only testimony from a witness who had been sworn in could be used against Gerald. And you'll remember that Mrs. Cook never showed up at either hearing 1 or hearing 2. So she didn't testify or provide information that would support a finding that a lewd phone call had been made by Gerald, nor did she sign a written affidavit that got submitted in court. So the U.S. Supreme Court finds that Gerald had a constitutional right to confront the witness. That means ask her questions. So he had a right for her to actually be there in the hearings and then ask her questions that might provide more information, perhaps information that his friend was the one who made the lewd comments instead of him, that would have helped him in his case. So this case, In re Galt, ends up being a landmark decision in the United States system, and it ends up reshaping juvenile justice across the state and federal courts. It gave children many of the same due process rights long held by adults who had been charged with crimes. It was the first time that the U.S. Supreme Court recognized that juvenile court cases are like adversarial criminal proceedings, that youth have the right to a defense lawyer, that the former rules of criminal procedure apply to juvenile cases, and that youth must have a chance to present their side of the story in an open hearing. And it reversed decades of practice in the state juvenile justice systems where juvenile judges were said to be benevolent custodians, empowered to look after the best interest of children when their parents were unwilling or unable to keep them out of trouble. But where often the reality meant locking youth behind bars for long stretches without representation or other basic rights. This case continues to be the subject of a lot of debate today, and it will probably be the subject of debate in your tribal justice systems if you apply the rights that the U.S. Supreme Court applied in Galt to the tribal court process. So if you just pause and think about what happens to youth in your tribal justice system, some of you may find that it's very, this Galt process is very familiar. I think I might have lost our slide. Let's see.
They should come back up here shortly.
Okay. There it is. Okay. Thank you. All right. So this Galt case is interesting from a number of angles for us in tribal court. Some of us may find to our horror that our tribal court hearing process looks a lot like the Galt case, and that we don't see all those protections in our tribal juvenile cases. And that would be understandable where many of our tribal courts have copied older process from the state court systems, and maybe even older than 1960s. And I do still see some of that out there. So I hope that Galt inspires you to go and take a hard look at how the hearings are happening in your tribal court process. All right, so let's come back to a little bit about the legal issues here. So one of the things that people don't immediately recognize, I think, is that we have two parallel systems of law running when we're talking about tribes. There is the U.S. Constitution and the rights that it protects that affect federal and state courts. And then in the tribal system, tribal courts are not bound by the U.S. Constitution. My law students at UCLA would always look at me in horror when I said this. But the U.S. Constitution does not govern tribal government or tribal court proceedings. Instead, Congress passed a law in 1968 called the Indian Civil Rights Act. And this is the piece of law that Congress expected tribes to follow when they make their own laws and run their own court systems, and to protect the rights through this statute. Now, there's a whole bunch of rights listed in the Indian Civil Rights Act, but one of the other things that people don't realize is that most of them are for adult criminal proceedings, and they don't apply to juveniles directly. So the only part of the ICRA that applies to juveniles is this part. No Indian tribe, in exercising powers of self-government shall deprive any person of liberty without due process of law, liberty or property. And so we get a very general due process protection for our youth in our tribal court coming from Congress through the Indian Civil Rights Act. Some tribes incorporate the provisions of ICRA straight into their constitutions. So the tribal constitution may just copy this language. Some tribes put it in a tribal statute or ordinance. Some tribes refuse to even recognize ICRA or just treat it as a guideline. And so you'll have to dig around in your own tribe's law to see where you're finding the Indian Civil Rights Act. But that said, it only provides a very general right, the right to due process for youth. And what does this mean, the right to due process in tribal courts? Well, if you're a lucky young person in your tribal court, your tribal judges may have incorporated a definition of what due process means into the tribal judges' written opinions or court opinions, and this is called tribal common law. And without giving you a whole sort of course on tribal law, you just should know that there are multiple ways that laws can be made in a tribe. It can be made in the Constitution. It can be made in a tribal ordinance or statute. The judges can, in a sense, make law when they have a written opinion and they explain the rules that apply to the people in the case in court before them. And then those rules get applied to similar cases in the future when the judges see a similar fact pattern in a case in juvenile court. So it's possible that tribal judges have explained what due process means for youth in the court opinions. And you would have to go collect all those court opinions and read them to figure it out. Okay, let me just pause there for a minute. Are there any comments or questions at this point?
I'm not seeing any questions right now, but if you have a question, you can enter it in the Q&A box, and those come directly to us as a presenters, and so we can read those and address those to the group.
Okay, so I'll occasionally just stop and see if there's questions because I know this material is pretty dense. And I encourage stupid questions. Those are the best ones.
Well, this is not a stupid question, but there is, what is considered due process in tribal court may be different, or this is more of a comment, may be different than due process in other non-tribal courts?
Yes. I could give you an example from Hopi. Instead of using the term due process, we sometimes use the term fundamental fairness. And then we talk about custom and tradition and what is understood to be fundamental fairness in the traditional system. And the definition varies depending on the kind of case it is. But you're absolutely right that tribes could define due process in a completely different way than in the Western system. That's an excellent point.
Well, thank you, Lauren, for sharing that.
All right. So let's look at how the U.S. Supreme Court defines due process. So now we're in that parallel universe here where the U.S. Supreme Court is reading the United States Constitution and it's defining what due process means for juveniles, but in federal court and state court. And so while none of this law binds tribal court process, it is binding over the years for the state courts. And it's interesting for us to kind of look over into that parallel universe and see what's going on. So the U.S. Supreme Court has identified what I'm seeing as sort of 8 basic rights for juvenile court, or for juveniles in juvenile court. And the first is, before we go down the list, just so you know, the stars mean that it comes from In re Galt. And the other symbols are broken down at the bottom, and it shows you the U.S. Supreme Court case where the rule comes from. So the first right is obvious. It's right to counsel, right to a lawyer. The second is a right to be notified of charges. The third is a right to a speedy trial. The fourth is a right to confront and cross-examine witnesses against you if you're a youth, and to subpoena and call witnesses on one's behalf. This is a big deal. If you're a tribal court working with a low budget, perhaps you don't have law enforcement, perhaps you don't have process servers, and you want to hold a hearing, but no one will show up to your hearing. Your witnesses won't show up. Or maybe nobody bothered to tell them to show up. Then you are having a really hard time guaranteeing a right to that young person in front of you that they can ask that witness questions, or that they can call witnesses on their own behalf. They need the help of the court system to subpoena or notify and mandate that people show up on time and actually participate in that hearing. So that one has a lot to do with money and a court clerk that knows what they're doing, and organization so that you make sure you get people to the right place at the right time. The U.S. Supreme Court also guarantees right to a fair trial. The youth also has the right not to be a witness against oneself or otherwise incriminate oneself. This is a big problem in tribal courts, where usually a judge will take an admission from the youth. So basically ask them during the first hearing whether they admit that they did the thing that someone is saying they did. And then the youth will admit that they did it, and then the case will be scheduled right on to disposition, and there will be no trial. There'll be no taking of evidence because the judge is using the admission as the basis for finding that he did the bad thing and that he's a delinquent, and now he should just go to sentencing, basically. So that's a really important right, the right not to be a witness against yourself, not to be made to admit. And then the seventh one is that the juvenile has a right, in his case or her case, not to be transferred to the adult criminal court without due process. And historically that's meant a hearing in juvenile court where they hear from everybody about whether the circumstances are appropriate to transfer someone to the adult criminal court. I did take a look at the 2016 model code, and I think they completely took out transfer hearings, making it impossible to transfer someone to the adult criminal court. And so that may be a trend that we start to see, that that's no longer a thing. I'm still pondering how I feel about that, but in general, you should try to keep your cases in juvenile court. And then the last right here that the U.S. Supreme Court is focusing on is the right not to be found a juvenile delinquent, not to be found to be a juvenile delinquent, absent proof beyond a reasonable doubt. So this tells me that the U.S. Supreme Court is treating sort of conviction of a juvenile offense the same way they would treat conviction of an adult crime. And they're making the standard of proof very high, so it's hard to show, it's hard to prove that the youth is a juvenile delinquent. Now, interestingly, the U.S. Supreme Court did not find that youth had a right to a jury trial. So in the state court systems, these are all what we call bench trials, where only the judge decides. There's no jury that is, voting to convict. There's only the judge. And then just a reminder to you all that even though I'm showing you all these U.S. Supreme Court cases, they are not binding on tribal courts, that we're bound instead by the Indian Civil Rights Act and the due process and equal protection provisions of that Indian Civil Rights Act in tribal court. All right. So I am going to, let's go to the next slide. And let's talk about the Model Indian Juvenile Code. So first of all, just remember that this is a different model than we talked about in session 1. In session 1, we were talking about the 1989 Model Juvenile Code that was compiled by the National Indian Justice Center. And now we're going to take a look at the 2016 Model Indian Juvenile Code that was originally compiled at the University of Washington and was eventually updated and adopted by the federal government as the Model Indian Juvenile Code. So this is the most current revision, and let me tell you a little bit about it. So apparently, in 1986, Congress passed a law requiring the Secretary of the Interior to develop a model juvenile code. And back then, they were concerned with making it consistent with the Juvenile Justice and Delinquency Prevention Act of 1974. And the provisions of the model code were supposed to relate to cases involving Indian youth who were arrested or detained for alcohol or drug-related offenses. So they were really thinking of a model code that was dealing with drug and alcohol. So the very first code, as I described, was drafted by the National Indian Justice Center in Northern California. And that's the code that we broke down in our first session of our webinars. But many years have now passed, and since that original code was drafted, the field of juvenile justice has really changed. So now we have all this research on adolescent brain development, and we know that adolescent brains develop much later in life than we thought. We also know that very common approaches to juvenile justice in the state systems have been shown to be ineffective, and actually some of the more punitive processes have actually been shown to increase juvenile delinquency rates. There's also been a move away from punitive models of juvenile justice in favor of restorative justice approaches, approaches that balance accountability and community safety with rehabilitation of children who have committed delinquent acts. So we talked about this a lot in the last session. Just now we know more from science, and we have more time to look at what works and what doesn't work in the juvenile system. So this 2016 Model Indian Juvenile Code was adapted from a draft code that was put together by the Native American Law Center at the University of Washington School of Law. And they have been funded by the John D. and Catherine T. MacArthur Foundation under an initiative that foundation had called Models for Change. The Models for Change initiative is a multi-state initiative that works to guide and accelerate advances to make juvenile justice systems more fair, effective, rational, and developmentally appropriate. So that original code was developed in partnership as part of a bigger agenda, a nationwide agenda. So that draft from the Native American Law Center was adopted and changed to become the 2016 Model Indian Juvenile Code. So some of the key principles from this 2016 code include a consistent and rigorous preference for alternatives to secure detention. There's a preference to do anything but detain the youth. Also, it favors informal and community-based responses rather than formal proceedings in juvenile court. It includes opportunities for diversion at every stage of the proceedings. It includes rigorous safeguards for the fundamental rights of children and their parents, and that's the bullet that we're really talking about in this session number 3. We're really looking at the rigorous safeguards for the fundamental rights of children. And I'm not going over the other objectives here because that gets us to the one that we're talking about today. Okay, so let's look at some of those provisions. So there's 5 preliminary provisions from the 2016 Model Code that I wanted to talk about. And this is the first one. It's important to understand how the law views who is a party to a case in tribal juvenile court. So this is interesting. Under the 2016 model, a party is defined to be the child or the youth. The tribe is a party to the case. And then at some point in the process, the child's parent, guardian, or custodian is also a party to the case. And I find that interesting that they don't have party status all the way through. And that tells me that this code is going to give them different rights than the child has in the court process. All right, so let's look at some of the due process rights. So one of the things that should just jump out at you here is that the model code is defining what due process means in tribal juvenile court. So right away we see here that the code is saying that the parties shall have the right to due process. And it includes things like notice of the proceedings, opportunity to be heard, an unbiased finder of fact. That means the judge can't be biased in the case, which might be hard to do in a tribal community where everyone is related to everyone. Also, the parties have a right to discovery. And discovery is that pretrial procedure in a lawsuit where the parties can obtain evidence from the other party, like the person prosecuting them, and they use all kinds of discovery devices for this, and like a deposition, for example. I'm not going to go into all of that, but basically you have a right to get information from the other side in a court case. They also have a right to testify, a right to subpoena witnesses, a right to introduce evidence, a right to cross-examine witnesses. So it should be jumping out at you that those rights, those 8 rights that were in the U.S. Supreme Court opinions that applied to the federal and state courts are being incorporated now into tribal court if you adopt the 2016 Model Juvenile Code. And the way it's coming into tribes is through the statute instead of through the U.S. Constitution. Oh, let's do the last one. So they also, the parties have the right to findings in juvenile court that are based solely upon evidence properly admitted in hearings before the court. In other words, if you're a juvenile or youth who is in a court hearing in this tribal court, they can't find that you made a lewd phone call unless there's actual evidence supporting it. And you're going to see here that that does not include usually the admission of the youth. So there has to be some other information before that court can find that you're a juvenile delinquent. Okay, so let me take a breath here and just see if there's any questions or comments.
I don't see any questions, but we did put the 2016 Model Indian Juvenile Code in the download pod, so if you would like to download that, you can keep that for later and go back and review the slides or these materials along with that, and any other things that Pat is pointing out about that version of the code.
Okay. So I guess I'll just pause for a minute here and say that I'm hopeful that we'll get through the whole PowerPoint set, but I also don't want to just sort of, read it all to you. So I'll just pause and see from time to time if we have any back and forth, and I'll do my best to give you some stories to make it more interesting. Even my eyeballs roll back to the back of my head sometimes reading code. So we'll do the best we can here and see how far we get. Okay. So another section of the 2016 Model Code, and a hallmark of this code actually, is the right to counsel and related provisions. And you can see here that the code requires that the child shall be represented by counsel at all stages of the proceedings. And that, interestingly though, the parent, guardian, or custodian only has the right to a lawyer at the disposition stage, that's the sentencing stage, and only in proceedings for contempt against the parent, guardian, or custodian. So let's say a parent is not cooperating with the court. The judge may order them to attend hearings and they don't show up. And so then the judge says, well, I'm going to order that you show cause why I shouldn't hold you in contempt and possibly throw you in jail if you, as to why you're not showing up. So the right to counsel for the parent, guardian, or custodian is a lot more limited here. They don't have a right to a paid-for lawyer until the sentencing stage. And this could be a different lawyer, I suspect, than the child's lawyer, depending on the circumstances. Oh, and the other thing I wanted to tell you about this is that the code, the 2016 code, presumes that these are licensed attorneys. And that's a very expensive proposition in tribal jurisdictions that are used to using lay advocates who didn't go to law school and are not licensed or may not be licensed. And so that's an important consideration here. All right, so let's look. Oh, wait, I wanted to tell you about Ron Whitener. So let's go back a slide. So this picture here on slide 17 is a picture of Ron Whitener, and he's one of the primary drafters of the 2016 Model Code. He graduated from the University of Washington Law School in '94, and he worked as in-house legal counsel for the Squaxin Island tribe, and I guess he's a member of that tribe. In 2000, he ended up joining the Northwest Justice Project in Seattle, where he represented low-income Native American clients in criminal and civil cases in tribal courts in western Washington state. And then in 2002, he joined the University of Washington Law School faculty, where he created the Tribal Court Public Defense Clinic, and they served as the public defender for several western Washington tribes. So that gives you some sense of why this model code is so rights-heavy for juveniles. Okay, a little bit more on the right to counsel provisions from this code. Interestingly, under this section, neither the child nor his or her parent, guardian, or custodian can waive the child's right to be represented by a lawyer. So that kid is going to get a lawyer no matter what in these cases. The parents can't deny the child that lawyer. And if they don't already have a lawyer, if the child doesn't already have a lawyer, the juvenile court is going to appoint a lawyer. And then I think I'm not going to do the rest of this code. Let's go to the next slide. So another fundamental right that's statutorily required here is the right to an appeal. Remember in the In re Galt case that Jerry Galt did not have a right to appeal the order finding him a delinquent and sentencing him to that 6 years in Arizona juvenile courts. There was no right to an appeal. Well, after In re Galt, of course, the states changed that, but there was nothing making the tribes change it. So if you adopt the Model Indian Juvenile Code, this provision is now going to require that any party to the proceeding can appeal from a final order of the juvenile court and the finding that the child committed a delinquent act. So if a tribal judge finds that the youth made a lewd phone call and sentences them to 6 years in a detention facility, the child now has a right to appeal that to the tribal appellate court. Okay, so let's stop for a poll question here.
Nick, you can bring those over. So it'll be the other set, Nick. You can hold on 1 second and we'll bring over that other set of questions. All right. I see we have our second set of questions. Hold on 1 second. We'll have those up for you to answer. If you'll bear with us for just a minute, sometimes technology is fun. We had a number of poll questions we wanted to engage with you all in because it helps us understand, what's occurring within your individual communities. And so we answered a few of those earlier, and we had them blocked together. So we are going to pull a couple of those up. In the meantime, I know, Pat, you had a couple of discussion questions that we had talked about prior to this session. And so for the group, Pat, out of those other questions that we had wanted to discuss, is there a question that we could use right now before we pull up those other polls?
Sure. So I would like to know how familiar you all are with the juvenile court proceedings, and I'll list 3 of them here, and then you can just type in. Do you want their answers in the Q&A box?
They can put them in the chat box.
Oh, in the chat box. Okay. So I'm going to name 3 court processes for tribal juvenile courts, and you all let us know if you're familiar with this, or if you're not, or if you're very familiar. So here are the 3. Do you know what an initial or preliminary hearing is? Do you know what an adjudication hearing is? Do you know what a disposition hearing is? Are you familiar with these processes? And I'll say them one more time. So the first is initial or preliminary hearing. The second is adjudication hearing. And the third is disposition hearing.
Thank you, Pat. And I see individuals are typing, so feel free to share what Pat just asked. Initial hearings, adjudication hearings, disposition hearings. And if you're not familiar, that's fine too. I know we had a couple people earlier talk about they're new to the court system, and so if you're either newly practicing within a juvenile justice setting, or if you're a behavioral health services provider or ancillary services such as community services, social services within your tribe, but you're going to be connected to tribal youth programs, that's why we're doing what we're doing. The hope is that this series will be helpful to those of you who are both in the legal background and who are not, because it's hard to understand all the different processes and procedures within a court system if that's not your educational background or your work history. And so we're glad to have a range of people that are joining. So we have several people that have answered, some moderately familiar, those that are familiar with preliminary hearings and adjudication hearings, some who are not as familiar with tribal juvenile court settings in general. Question is, what is the difference between an adjudication hearing and a disposition hearing?
So that's an excellent question, and the clearest, simplest way I could describe it is that an adjudication is basically the trial where the judge is trying to figure out whether the young person did the thing that they're accused of doing, and you hear witness testimony and you take evidence, and then you ultimately decide whether you have a juvenile delinquent or not. And then if there's enough proof that the youth made the lewd phone call and is a juvenile delinquent, then another hearing is scheduled called the disposition hearing. And the easiest way to think of it is it's like a sentencing hearing where the judge is going to take information and figure out what kind of sentence or disposition should apply to this young person who's been found guilty of doing a bad thing. They tend to not call it a trial and sentencing in juvenile cases because they don't want to make it sound like a criminal process, even though I'm telling you that a lot of it is like a criminal process. And that's why they use the terms adjudication and disposition instead of trial and sentencing.
Thank you. I know some of you are still sharing your responses. We have some law enforcement that are familiar with the hearings, and then thank you for the clarification. In their tribal court, we only refer to sentencing as adjudication hearings.
Oh, I should say one more thing about that. In some tribes, they do it all in one hearing. They do the adjudication and the disposition back to back, and so to an observer, it will look like it's just one hearing, but they're actually doing it in stages. So you do stage 1 and stage 2, which essentially is 2 different hearings.
Well, we're going to go ahead and pull our polls back up. Sorry we had to get past the first ones we had done. So the first poll is, what is your level of knowledge related to rights and evidence in juvenile court? The second question is, does your tribal constitution or tribal statute contain a Bill of Rights? And the third is, which of the following rights do you think that your tribal juvenile law contains? And we referenced several of the rights that Pat has mentioned earlier, and you can go ahead and type in what you do know. If you don't, that's a great way to go back and search through these and see what your tribal code actually contains. We know you might not do that right this minute, but after this webinar is a great time to go back to your own code and review what rights your youth are guaranteed under your Constitution. And so we would love for you guys to share in these 3 polls. Again, we can discuss those as a group, the different responses. And if you don't know, you can answer that. You know, if you're not sure, that's fine too, because it's just an opportunity to go back and learn more about what's occurring in your own community's statutes and law and order codes. I know we have some moderate and still learning. I know just from familiarity with our audience, I know that we do have several individuals who served in judicial capacity as judges. I know a couple of prosecutors are joining us, and so I'm sure there's a range of knowledge related to what rights and evidence are occurring in the juvenile court. Some of you don't have any knowledge. We have a moderate and still learning, average amount of knowledge. As far as the tribal constitution containing a Bill of Rights, Choctaw does not have a juvenile code at this time. And then a couple other answers of just no or no. We don't know what communities those are from, but it's good to know that we have differing things happening within different communities. And then as on our last question about what rights do you think are in your juvenile law, right to counsel, tribal court is transitioning to a contemporary court where a law-trained judge presides as the children's court judge. And then another response is that there's the first three rights: right to counsel, right to be notified of the charges, and the right to a speedy trial. Another response: right to speedy trial and right to a fair trial. So it's looking like a lot of people learning about what rights do exist. Several communities responding of either no Bill of Rights listed or maybe a limited number of those rights being listed. And then of the rights in the third question, not all, some but not all of those rights, Pat.
I'm not surprised. Of course, we have not been part of that evolution of rights coming out of the U.S. Supreme Court for the state court systems because, of course, we're not bound by the U.S. Constitution in the way that state courts are. So we would have had to rely on each of our tribal judges, incorporating those U.S. Supreme Court cases in their tribal judicial opinions. And some places have done some of it. It's ad hoc. It's not showing up in the written constitutions and tribal statutes unless, a tribal attorney thought to do it for juveniles. So this doesn't surprise me at all. And that's why the model code is drafted the way it is, in hopes that tribes will pick up more of those juvenile 8 rights and put them in their juvenile laws.
So you can close those out, Nick. Thank you all for sharing. We appreciate it when you all share with the group. And then we'll go ahead and move on to the next slide.
Okay, we should be at slide 21 now. And I just wanted to come back and have some context here for a minute. So if you'll remember during our very first session, I talked about how there were sort of 3 different sets of symptoms that juveniles might have or youth might have that would bring them into a tribal juvenile court. And one was that they weren't showing up to school or they were being seen as being truant. And the second category was that they were seen as committing certain kinds of offenses that wouldn't be crimes if they were an adult, but that tribal law has deemed to be a status offense. Things like running away from home, not getting along with their parents, not showing up at school. And we talked about how under the 1989 model code, those status offenses or symptoms would show up in the court process called a family in need of services. And then there was that third category that we call juvenile offender. And those are the symptoms where tribal youth are actually committing or are alleged to be committing crimes that are defined under the tribal law and order code or the tribal criminal code. Things like theft and assault and, all the way to murder. So in this session, we're going to only be talking about that third category of juvenile offender. So with all this elaborate sort of court process, adversarial court process that we're talking about today, we're only talking about the subgroup of youth who are alleged to have committed crimes that are defined by tribal law. And even so, we're only going to talk about 3 stages of the juvenile court process here. So when we're dealing with juvenile offenders, there's 3 areas where all these rights seem to really matter. And the first is when they interact with police or when police interact with youth. The second is in this hearing that is a first hearing that I call a preliminary hearing. Actually, I don't call it that. The 1989 model code calls it a preliminary hearing. And then the 1989 code calls the trial an adjudication or an adjudication hearing. So let's just step back out for 1 second. I mean, why do we care about all these rights and evidence protections for youth? I mean, Is it really that important? Well, what are some of the consequences for youth if they get processed in a tribal juvenile court all the way out through the end, meaning all the way through sentencing or disposition? Well, they have a stigma the rest of their life as having a court record and being found to be a juvenile offender or a juvenile delinquent. They have a police report record. They may become a registered sex offender if that was the nature of the offense. They may end up in secure detention, and that's really bad from a developmental perspective because, remember, their brains are very plastic. There's a lot of plasticity in there. They're learning. They're absorbing like sponges. So if you throw them in secure detention with other more professional juvenile delinquents or even in jail, they are going to absorb the values, lifestyles, priorities, etc. of their peers at a time when they're very susceptible to their peers. And they also could end up in jail or prison in some systems where they either waive them into or transfer those cases out of juvenile court into adult criminal court. Also, there may be other real punishments that hurt. So, yeah, I would say if it were my kid going through my tribal juvenile justice system, I would want them to have the full array of rights and evidence protections to make sure that they aren't found to be a juvenile delinquent and then sentenced when they didn't do it, or maybe they didn't do the exact crime that they're accused of. Or maybe there's a better way for them to be handled in the system that's more therapeutic. All right, so I think I've made my case on this one. Let's go to the next slide. All right, so this, you should recognize this from our first session. This is a diagram of the juvenile court process in the 1989 code. And what I really want to focus on is the top line of it. So let's go from left to right. So in the beginning, somebody makes an allegation that a young person has committed a crime. The court is notified, and the who works for the court investigates to see whether or not there's enough information to support that this young person has done what they're alleged to have done. And then the juvenile counselor can process this whole thing before it goes to court. In that informal adjustment process, it's basically meetings with the parents and providing services and getting agreements from the parents. But let's assume none of that worked. And so now the juvenile counselor is going to file a petition with the formal tribal juvenile court. And basically they're going to charge this youth with having committed a crime. And so then a preliminary hearing will be held. In more bare bones tribal systems, they might actually take guilty or not guilty pleas at this stage. And they might also inform them of their rights and what they're charged with. They might appoint a lawyer or not. So a preliminary hearing, it takes care of these preliminary tasks like notice of rights and appointment of counsel and maybe pleading. And then the next phase is the adjudication or the trial. And this is where a judge has to actually decide whether he thinks or she thinks that this young person committed a crime. And so they're actually going to hear evidence, take evidence, and weigh it to see if they are going to find that they committed the crime and then should go on to a disposition hearing. And then, like I said, the disposition hearing is the last hearing. Well, it may not be the last hearing, but it's the next hearing. And this is like a sentencing hearing. In many traditional systems, you might even call it a sentencing hearing. Under the 89 code, it's called the disposition hearing. All right, so that was just a little bit of review. All right, let me bring you forward into the 2016 model code. So it's basically the same process, but change the names a little bit. So instead of calling the juvenile offense a juvenile offense, they call it a delinquent act. Same thing, the youth is accused of committing a crime under the tribal law. And then that case is investigated by a juvenile case coordinator, different name, same job as the juvenile counselor under the 89 code. And then a delinquency petition is filed. Assume this case doesn't hurt it in any way. So a delinquency petition is filed, and then there's an initial hearing. They call it initial instead of a preliminary hearing. And then there's an adjudication. That one holds the same name, and then there's a disposition hearing. Okay, so we're going to look at the code provisions, or I should say the statutory provisions from the 2016 code, and we're going to start with all the way over to the yellow box on the left at the very beginning, when a youth is just alleged to have committed a crime or a delinquent act. Okay, so go to the next slide. So the provisions in the 2016 code that seem relevant here are under the caption of interrogations, because we're really looking at what's going on between the police or any other official in the government who is doing investigation and questioning. It comes up under Section 202 of the 2016 Model Code called interrogations. And I thought I would pause here. I have some pictures later on in the slide set, but I want to give you a story to go with these code provisions. So the story I want to tell you is a true story, and it's 1989. It's a story that happened in New York City in 1989. And this is a notorious story. It's often referred to as the Central Park Five. And let me just tell you the story. So in 1989, a young man named Raymond Santana, who was 14 years old, was picked up by the NYPD. And he was picked up because people had been calling the police department complaining that as many as 30 black and Latino boys were roaming through Central Park, harassing and insulting bystanders. Soon after, Santana was joined by 4 other young men, Anton McCrae, who was 15, Kevin Richardson, who was 14, Yusuf Salam, who was 15, and Corey Weiss, who was 16. They were picked up and put in 2 different police precincts in New York City. They did not all know each other when they were arrested. And all 5 of them were already in custody when the police made a gruesome discovery in Central Park. In the park, the officers found a female jogger who was along a path, along a river in the north woods of the park around 2 a.m. The young woman was near death. She was bleeding and unconscious, and she had been brutally assaulted and raped. After 2 a.m., the police spent the next crucial hours connecting the dots between the boys and the jogger. However, the newspapers did not wait for a trial and a jury verdict to find Santana and the 4 boys guilty. They started reporting as soon as they could about the offense, and they shared a story that the case had been closed because 4 of the 5 boys confessed to the assault and rape. The 4 youngest boys spent 5 years in a juvenile correction facility. Weiss, the oldest boy at 16 years of age, served nearly 12 years in prison as an adult. And while in prison, Corey Weiss had a run-in with a man named Matthias Reyes, who was serving time for the 1989 rape and murder of a pregnant woman. And Matthias Reyes was also linked to 7 other rapes in Manhattan. So Matthias Reyes ends up telling a correctional employee that someone else was serving time for the crime he committed. And word of this admission eventually made its way to Manhattan, and in 2002, the district attorney's office compared Reyes's DNA with samples collected from the Central Park crime scene. Those samples never matched any of the boys who were imprisoned for the assault and rape. Instead, the test showed that the DNA was a match for Matthias Reyes. Okay, so clearly in this case, and by the way, you might have all heard of the Innocence Projects around the country where law schools and law professors are going back in and they're testing DNA in cases of people who they think are wrongfully convicted and sentenced, and they're getting them out. So this was one of those cases. But for our purposes, we want to look at the interrogation and what happened to these boys, how they were investigated and interrogated at the front end here. So let's talk about Santana, who I think I said was 14 years old here. Just to double check. Yep, he was 14 years old. He ended up sitting across the table from an assistant district attorney, who's a prosecutor, a police detective, and then there was another police officer who was holding a video camera. So he had been in custody for about 27 hours before this. He'd been interviewed twice, but the camera was not switched on until about the 27th hour at 2:30 a.m. in 1989. He was read his rights and he mumbled yes. By the time the police first questioned him, he hadn't slept for about a day, and he was told repeatedly that he could go home as soon as they sorted out his story, and that any charges stemming from the night were likely to go to family court. The young man, Santana, said that the detectives didn't even start taking notes until the interview turned to rape. The other boy, he was told, said that he was the rapist. And at this point, Santana, who was tired, began to give details of the assault in hopes of getting out of the precinct. Some of what he said conflicted with the information given by the other boys, like what the woman was wearing, who actually raped her, how she was beaten. Nevertheless, he gives details to them so that he can go home. So people have looked back at this case. It's been scrutinized a lot, and this process has really been scrutinized. And even the U.S. Supreme Court has looked at the issue of the use of deception and misdirection in interrogations. And over the years, the U.S. Supreme Court has defended police use of deception and misdirection at this stage. There was an early case, Frazier versus Cupp in 1969, where the U.S. Supreme Court said that police deception is not necessarily police misconduct. And this has come to be known as the Frazier standard, which allows detectives, or allowed detectives in the Central Park 5 case to tell each boy alternate theories about who did what to the victim. For example, it allowed the police to tell one of the boys that the investigators found his fingerprints on the victim's clothing, and that deception prompted him to confess. And so this is a common practice, use of deception and misdirection. So there were some other interesting pieces of information from this story that I found fascinating. One is that apparently all these interrogation techniques are codified by a private firm called John E. Reed and Associates. And so lots of law enforcement agencies use the Reed and Associates techniques to interrogate alleged offenders in their systems. And so there's been some commentary about the use of these techniques. And there was a professor of psychology named Saul Kaysen who stated that by definition, interrogation is a guilt presumptive process. What does that mean? That means that by the time police start to interrogate, they are presuming that the interrogatee is guilty. And he says that the judgment they make at the interview stage is pivotal because if they determine that a suspect is truthful and innocent, they're going to send him home. If they determine that he's lying, then they move to interrogation and they apply these interrogation techniques that involve deception and misdirection. And so I just want you to think about that when you're thinking about that 14-year-old adolescent brain who's been sleep deprived and hungry and scared and just wants to go home, and he's told he can go home if he just tells them, you know, basically what they want to hear. They won't say that in words, but that's the effect of it. Okay, so I wanted to give you a story to use or to hold in your mind as we move through these model Indian Juvenile Code provisions on interrogation. So think about this young kid, Santana, and his other 4 friends in the interrogation process when we look at these provisions. Okay, so the very first thing we need to do is have a definition because, you know, in the law you just have to have a lot of definitions. So let's start with section 2.02.100. I'm just making sure I'm getting the same page as you here. Okay, so the model code defines what is interrogation, and then they define what is custodial interrogation. And so they're defining interrogation as when a law enforcement officer, let's just look at the law enforcement officer first. When that law enforcement officer asks a child a question, so that's what interrogation is. But it also includes where the law enforcement officer subjects a child to any words or actions that the law enforcement officer knows or should know is likely to elicit an incriminating response. And I thought to myself, well, what is an example of that? So I dug around a bit and I found an example. So what if the law enforcement officer is talking to the child and the child is not answering or not giving the answers the law enforcement officer is looking for? So the law enforcement officer allows the child to talk to his mother, and during that time the police record the conversation between the child and the mother. Well, that would be an example of subjects a child to actions that the law enforcement officer knows or should know is reasonably likely to elicit an incriminating response, because that kid is probably going to be talking to his mother pretty freely, and his mom can probably get him to say what he did. So that would be an example of an interrogation where you don't have the police officer directly asking the questions. Okay, so the second definition is a specific type of interrogation. It's a custodial interrogation. And this is any interrogation during which a reasonable person of the child's age and the child's position would consider himself to be unable to terminate the encounter. So you're looking through the eyes of the child here. What would a reasonable kid of that age think? Would they think that they could stop talking to the law enforcement officer? Well, if they're in an interrogation room in a police precinct like the Central Park 5 kids were, and they're surrounded by law enforcement officials, I bet they don't think they can leave. You know, maybe there's a shut door. I bet they really, that's like the classic form of custodial interrogation. So I thought to myself, okay, what would be another example where you're not in an interrogation room in a police precinct? So I found an example in a school setting. So if you have a student who is in school and they're told to report to the faculty room by the principal or any official, And then when they get to the faculty room, the school official asks questions of the child at the direction of a police officer who is present. That could be a custodial interrogation as well. Because from the perspective of the child, they might feel like they're unable to terminate the encounter. So judges really have to look at the details of the questioning to figure out whether the interrogation or the alleged interrogation is a custodial interrogation. Okay, let me just stop for a second and see if there's any questions or comments so far.
I was just going to comment that, you know, for our tribal practitioners that are on here, I think one of the elements to all of this is what we talked about earlier, and that's one is if you're not having to, but if you do collaborate with local school and county partners, and having the knowledge and understanding of, you know, what processes are occurring at the state level, and then what processes are going to be occurring within your tribal court system, and why it's integral for all of your staff to know and understand what rights are guaranteed to your youth, and what's going to come at play later as far as, you know, all of your government actors ensuring that you're following your Constitution and the rights that are given. And so I just think it's really important to understand, you know, all of these different components and ordinances and laws that are going to be at play, no matter what your role is in the system. And then further, when we're talking about this element of tribal law enforcement or other enforcement officers that might be engaging with youth, just the training and opportunities that are available through RTA Center, if you're interested in those. One of the things that we, and a core component of what we do is trauma-informed practices, and we do have resources for law enforcement if you're interested.
Thank you, Anna. Let's see. I do see something in the Q&A, but I can't read the whole thing.
I will open that up and we can read that. A question about an officer can have a social worker speak to the youth and ask questions while he listens behind a glass window. This would be an interrogation and acceptable ? I have seen this, but I do not like this process.
Well, okay, so I actually sit as a tribal judge, and I would be rather uncomfortable with that arrangement, but I can see how they are subtly getting around the restrictions there. So as a judge in my jurisdiction, I would have the ability to take testimony and weigh all those factors and figure out whether I thought that was permissible or not. And that's what judges do. They're going to get more information on the scenario and decide, you know, from that kid's point of view, was that a custodial interrogation or not? And judges are going to come down on different sides of that across the jurisdictions. Good example, though. Okay, so why the heck do we care about whether it's a custodial interrogation? I mean, we've got these nice definitions, but why does it matter? So there's two reasons why it matters. And I'm going to move us to the next slide, and then I'm going to tell you something about this. So all of this conversation is coming out of a famous U.S. Supreme Court case called Miranda versus Arizona in 1966. And I'm not going to tell you the details of the case, but just to say that under that case, the U.S. Supreme Court said that any incriminating statements made during a custodial interrogation are inadmissible at the trial unless the individual is first advised that he has a right to remain silent, has the right to consult with counsel, the right to have counsel present during the interrogation, and the right to an attorney who will be provided if he cannot afford one. So this is the TV show list of Miranda rights. And so if a custodial interrogation happens, a judge is going to want to know, if the statements made by the young person were made before or after their rights were read to them. And Miranda only applies in situations of custodial interrogation. So it starts to really matter whether or not these rights were read. The picture here is actually a picture of the Miranda rights. It was a card. I guess law enforcement officers carried these. And Ernesto Miranda from the Miranda case got a whole bunch of those cards, and he would sign them with his name and sell them to people. So I found a copy of that. I thought that was amusing. Okay, so remember that in the parallel universe of the federal and state systems, they're bound by Miranda and Miranda versus Arizona. But we're not in tribal courts. Now, our law enforcement officers may be trained by the BIA or the state, and they may be trained to apply Miranda. However, that might not be required under tribal law, and the tribal judge may not require it. So the model code, the 2016 model code, is now actively or explicitly setting this out in the model code. So now we're starting to incorporate those U.S. Supreme Court rules again into tribal law by statute. So this is the list of rights. This is the model code version of the Miranda rights. Prior to interrogating a child, law enforcement officers shall advise the child in the language the child will easily understand that the child has a right to remain silent, and that anything the child says may be used against the child in court, that the child has a right to have his or her parent, guardian, or custodian present during questioning, that the child has the right to be represented by counsel, to consult with counsel prior to any questioning, and to have counsel present during any questioning. So our tribal law enforcement and tribal officials would be required to say this to a child before interrogating a child. And I do note that they don't say custodial interrogation here, so I find that interesting. I don't know if they meant to do it that way. I'll have to read the notes on the code and see what they meant by that. Okay, so again, we're seeing U.S. Supreme Court rules being incorporated into tribes by the model code. So there's also a code provision that explicitly requires the presence of the parent or a lawyer. So they say no child shall be subject to custodial interrogation unless the child's parent, guardian, or custodian or counsel for the child is present. So you could see how this will pretty quickly hamper the ability of tribal law enforcement or other officials to respond, as first responders to an incident involving a youth and actually obtain any information. Because, you're going to have to call their parents, you're not going to be able to ask that kid questions unless their parents are there. And then once you tell them of their rights, they may ask for a lawyer. And I bet we're going to find in this code that a lawyer has to be there too. Okay, let's look at the next one. Okay, so all these fancy rules are really talking about what information that law enforcement or other officials collect from young people, especially admissions or confessions. What information can you actually use in a court hearing to prove they did the thing, made the lewd phone call, assaulted and raped somebody? If you don't collect this information properly, you aren't going to get to use it as proof in the court process. And so there's all this talk about what is admissible or inadmissible in court because the judge is checking to see whether you followed the rules under the code here. Okay, so this is about, this section is about inadmissible statements and derivative evidence. So let me just read it here. So A statement of a child made as the result of any interrogation shall be inadmissible as evidence against the child in any delinquency or criminal proceeding unless, 1, the child was advised in accordance with the provisions that we just read of their rights. 2, the child clearly and affirmatively waived his or her rights before being questioned. So you can still use some of what the kids say, but they have to have been read their rights, and then they have to have waived their rights. Now, many experts on adolescent development question whether juveniles possess the cognitive ability, the maturity, and the judgment necessary to exercise legal rights, including the capacity to knowingly, voluntarily, and intelligently waive their rights. Do they really know what they're doing when they say that they waive their rights? Right? Because then they'll start talking and then they will confess to something and then that confession will get used against them in tribal court. So one of the things the judge is going to look at is whether this waiver was voluntary, knowing, and intelligent. This also comes from the U.S. Supreme Court case of Miranda versus Arizona. Numerous Supreme Court cases have affirmed the importance of considering a juvenile's youth and maturity level when they're assessing the voluntariness of a confession. And the majority of jurisdictions are using a test called totality of the circumstances test. So the judge is going to evaluate these factors. He's going to look at the juvenile's age, their experience, their education, their background, their intelligence. He's going to look at whether they have the capacity to understand the warnings that were given to them, whether they understand the nature of their Fifth Amendment rights, the right against self-incrimination, and whether they understand the consequences of waiving their rights. And they're also going to look at the context of the questioning, like what is the relationship between the person asking the questions and the juvenile. So on an Indian reservation, for example, or in a Native community, it's often likely that we're related to each other or we all grew up together. So it's going to make, in this sort of totality of the circumstances test, it's going to make it harder to show an effective waiver of the youth's rights in tribal court. Okay, I'm gonna pause there again and see if there's any questions or comments.
Again, if you have any questions, you can type those in the Q&A box, and then if you have comments, you can type those in the chat box.
I guess the question I would ask you all is, do you think this is going to make it a lot harder to ever find a youth to be a juvenile delinquent in tribal court if you can't use information elicited from youth from questioning by officials or law enforcement officers?
I see we have a couple of people typing, so we'll wait for those.
I appreciate it when you all type in. It gives me a chance to breathe, talking so much.
We do have a question. At MBCI, we very rarely have youth statements used against them in a youth court.
Oh, that's great. Are they? Is it a standard juvenile court or is it a healing to wellness court?
We'll wait and see if we get a follow-up from that. So the response was, is that in a juvenile court setting, or is that in a healing to wellness setting, or even another diversionary court setting? I'll wait and see if we get a response back on that, and we'll do a follow-up if we get another comment on that. And yes, we do appreciate whenever you all share, and I think for your colleagues that are on, it's interesting to hear insights from the different communities that are joining, especially because today is really more about dialogue and discussion. You don't necessarily have to agree with what is written in the code. This is really just to take a survey of it and look at how the differing provisions in this code can work in conjunction with the code that you have now, or as you develop further your processes and procedures within your juvenile court system. Choctaw Police, this is a follow-up from that first comment. Choctaw Police know that they have to give Miranda warnings and question only with the parent guardian present. This is a standard youth court for juvenile offenders.
That's great. That's great. You have all the full-blown process.
Thank you for sharing that.
Okay, I'll get us going here again. So let's look at slide 29. So here's some of the pictures from the Central Park 5. That's the Raymond Santana on the right. And that's actually a screenshot from his confession tape. So one of the big debates going on in New York is whether or not police in all the precincts should be required to videotape all the questioning, like from beginning to end of an interrogation with youth. And actually, I think they might be talking about it with adults too, but definitely with youth. Because then you could later show that to a judge or a jury and they could see the context of the questioning, not just sort of cherry-picked videotape used by law enforcement, which is what was happening in his case. Remember, he'd been questioned for 27 hours. They held him, and he'd been questioned twice off video. So nobody knows what they told him in those, hours ahead of time. So one of the things we see here in this section from the Model Juvenile Code under B2 is that an electronic recording is made of the custodial interrogation. So clearly, the drafters of this code were very cognizant of what happened in the Central Park 5 case and the debate out there about recording interrogations so that a reviewer later could see the context. Okay, so this provision is still governing inadmissibility of statements made by youth and any evidence that might be derived from that. So, for example, if a youth confessed during interrogation to having assaulted someone, and then they said, oh, and I hid the gun under my car at home, that would be the derivative evidence. So the police could then go to his home and find the gun, and then that would be evidence, further evidence. But the problem is that it's derivative of a statement that might have been made during a custodial interrogation where they didn't give him his Miranda rights, or there might have been other problems with the confession. So this provision is looking at that kind of thing. So it says that a statement of a child made as a result of a custodial interrogation shall be inadmissible as evidence against the child in any delinquency or criminal proceedings unless the statement is made after consultation with and in the presence of counsel. 2, an electronic recording is made of the custodial interrogation. And 3, the recording is accurate and not intentionally altered. There's also a C here. The statement of a child was made as a result of an interrogation prior to or during which the child was subjected to threats or physical punishment. These conditions cause that statement to be inadmissible as evidence against the child in any delinquency or criminal proceeding. So you can't coerce a statement from a young person and then get that statement admitted at trial. If a juvenile court finds that a statement is inadmissible under this section, then any statements or other evidence derived from the inadmissible statement shall be likewise inadmissible as evidence. So that's the gun. You aren't going to get to have that be admitted as evidence if it came from a bad statement. Okay, so a lot of detail in this code. There is an allowance for other kinds of statements made by youth here under this section. So you can still admit certain kinds of other statements from youth. So if the young person makes a statement in open court and the child is represented by a lawyer, that statement can be used against the child. Also, if the child makes a spontaneous statement, even in interrogation, that is not made in response to the interrogation, that statement may be used. So if someone just, I can't take it anymore, I feel guilty, and they make their statement, certain kinds of things are characterized as spontaneous statements, and they can be used. Also, statements made in response to routinely asked questions. And if it's not a question that the law enforcement officers know or should know is reasonably likely to elicit an incriminating response. So there's some loopholes here that can be used to get in statements that might not otherwise be admissible in a trial. All right, so we're going to look at their big long list of factors relating to admissibility here. So once you're actually in court and you're actually having your trial, this rule is going to bind the judge to consider certain factors. So what if the law enforcement officers say that, okay, it was a custodial interrogation, and so we did give him or her, the youth, his or her Miranda rights, and then the young person said, I waived my rights. Okay, so once you get into, and then they confess. So when you get to the trial stage, the judge is going to have to do an analysis of whether or not that youth knowingly or voluntarily and knowingly waived their rights. And these are the factors that the judge has to look at. So the judge is going to look at whether the child had the opportunity to consult with his or her parents, guardian or custodian, or a lawyer before they made that statement. The judge is going to look at their age, maturity, and level of education. Again, you should be hearing some of those U.S. Supreme Court rules getting locked down in the model code here. They're going to look at the child's level of intelligence and mental development. They're going to consider whether there's any cognitive or mental disability or impairment. They're going to actually look at the child's physical and mental condition at the time the statement was made. They're going to look at how long the child was detained before they were interrogated and the length of time that they were interrogated before they made the statement. So, that Central Park 5 story should be hanging in the back of your mind here. 27 hours before they actually recorded the confession here. They're going to look at the environment in which the interrogation took place. They're going to look at the number of law enforcement officers who conducted or were present during the interrogation, as well as their physical characteristics and their demeanor. And they look at the use of deception. So now they're getting at that that test that I was telling you about. The code is saying they can't use deception, or it's going to be a factor in the judge's mind as to whether or not he will admit the confession. And then finally, they're going to look at whether either prior to or during the interrogation, the child was held in isolation, deprived of food, sleep, or subjected to other potentially coercive measures. All right, so the code is really locking down those rules that were coming out of the U.S. Supreme Court and other systems, other state court systems. Okay, any other questions or comments before we change topics here?
I'm not seeing any questions, but we're coming up on 5 minutes toward the end of the session.
Oh, you are right. All right. So we do have, in our next session, we're going to cover the nuts and bolts of the 2016 Model Code juvenile court process. So I should be able to carry over some of this, what we don't get to today, I can carry it over. Let me see what I want to finish off with here. I think I will do that. So I'll carry over the discussion of the provisions for the preliminary hearing and for the adjudication. And I'm going to move us forward here to my sort of forward. Are going to have, you should get a law certificate when you're done with this segment. Okay, so here are some observations. Focusing on the what happens when a case goes to trial without referrals or diversions. So this is the worst case scenario of how a youth might be processed through the system. I remind you that there's been huge juvenile court procedural changes since 1967 and in re Galt. These big changes have been happening in the state juvenile courts, and they will be huge changes for tribal juvenile courts if they adopt the 2016 Model Indian Juvenile Code for most juvenile courts at the tribal are doing this anyway. The third observation is that the Indian Civil Rights Act promises tribes will not deprive youth of their life and liberty without due process. But the enforcement remedy, if you don't adopt the model code, the enforcement remedy is very hard to come by. So you basically, a young person who feels like their tribal court has detained them unfairly, they would have to hire a lawyer and go file a petition in federal court. And it just really doesn't hardly ever happen, either because their stay in detention ends before they actually get heard, or they just can't afford the lawyer. It just doesn't tend to happen. Okay, these are my sort of final observations here on slide 53. So the tribe uses tribal statutory provisions from the model codes to back up and elaborate in much more detail on what due process means for young people. And we've talked about all those rights today. And we've been looking specifically at statutory provisions from the model code that impact three parts of the juvenile process: police and other interrogations, and next time we'll look at preliminary hearings and adjudicatory hearings. And then my final observation is that we've been using the model juvenile code provisions which protect youth at the highest level. But they also drive Western adversarial process into the tribal court system, and they may be quite expensive for tribes because the tribe has to provide for a licensed attorney at almost every stage from interrogation through the end here. So there are some big considerations to have, and I thought, I feel like we had one more polling question here, Anna.
We did. I didn't know if you wanted to ask that now or wait until next session. And maybe a little bit of homework is reviewing what we talked about today and maybe taking a look at that model Indian Juvenile Code if they haven't already, and then maybe we can get some feedback on that last question at the start of next session.
Okay. I would say that a big question that pops into my mind, especially for more traditional tribes and maybe some tribes in Alaska is, I would want to know, are you very concerned about using Western adversarial trial court process in your tribal court? And why or why not might you feel that way? Maybe just ponder that between this session and next session, and we'll come back to it.
I think that's a great question, and we did put everything in the download pod, so please make sure and download the documents in the download pod. Session 4 is going to be on Thursday, July 12th, same time, 1 o'clock Central. The link to register is in the chat pod if you haven't already registered for that. We look forward to seeing you at Session 4. Thank you so much, Pat, again. Appreciate all of the conversation and everything else that you shared today. Great presentation. We do have an evaluation link. We'd love for you to fill that out. And also, we had just a tiny bit of sound issue, but we will be archiving these webinars. And so anything that you missed, we can send you a transcript after that webinar. So if you missed anything, don't worry, we can get you filled in. Pat's email is at the bottom. My email is there as well. If you have any questions or if you want some kind of individual one-on-one contact about your tribal code, please feel free to reach out. Pat does have some availability to review tribal codes for those of you who are participating, and we very much want to be of service to you, and this entire series is being done to support your community and what you're doing, the work that you're trying to support in your community. So thank you all for joining. Please fill out our survey. Pat, we will see you again on the 12th of July. And thank you all for being here today. We hope you have a good weekend and holiday and safe travels if you're going to be on any kind of vacation between now and our next session.